Madam Deputy Registrar, would you please commence proceeding?
Thank you, President Saunders. Caribbean Court of Justice, Appellate Jurisdiction, an appeal from the Court of Appeal of Belize, hearing of appeal in CCJ Appeal BZCV number 5 of 2023 between the Attorney General of Belize, Ministry of Natural Resources, and Primrose Gabourel. The members of this morning's panel are Mr. Justice Saunders, President and Presiding Judge.
Morning, everyone.
Mr. Justice Anderson.
Good morning, Counsel.
Madam Justice Rajnath-Lee.
Good morning, everyone.
Mr. Justice Barrow.
Good morning, all.
And Mr. Justice Jamadar.
Good morning to everyone.
May we have the appearances, please? Thank you.
Good morning, Your Honors. If it pleases you, Samantha Matut, and I appear on behalf of the appellants in this matter, the Attorney General and the Ministry of Natural Resources.
Yes, morning again.
Good morning, Your Honors. I am Godfrey Smith, and I appear for the respondent, Primrose Gabourel. With me are Mr. Hector Guerra and Mr. Michael Arguelles.
Yes, good morning, Mr. Smith. Ms. Matut, are you ready?
Yes, Your Honor, I'm ready to proceed.
Yes.
Much obliged. Your Honor, what I would like to do, or how I would like to start this morning is if I can take Your Honors to an extract in respect of the decision of the Court of Appeal in this matter. And the specific extract that I would like to take the court is at paragraph 26 of the decision, and this is at page 25 of the record.
Yes.
And if I may be allowed to read, it says, although the action that led to the assessment was formulated as a claim for damages for violation of Ms. Gabourel's right under Section 17.
Sorry, what paragraph?
It's paragraph 36, and it is at
36. Thank you.
Yes,
Thank you.
page 25 of the record. Yes, please. I will start over. Although the action...
So, Ms. Matut, just saying you're reading from the minority judgment then, is it that?
Yes,
yes,
that's
thank
correct, Your Honor.
I just said I missed a part. Thank you.
Yes, thank you, Your Honor. It states, although the action that led to the assessment was formulated as a claim for damages for violation of Ms. Gabourel's right under Section 17 of the Belize Constitution to protection from deprivation of property, the admissions upon which judgment issued were that the land had been compulsory acquired by the Government of Belize and that Ms. Gabourel was entitled to compensation. And if I could take Your Honors further to paragraph 38 on the same page, it states, the point is important because it establishes that Justice James, in the exercise he was conducting, was concerned with assessing compensation for a lawful acquisition of land under the Land Acquisition Public Purposes Act and not damages for an unlawful acquisition of land outside of the Act. With that backdrop in mind, Your Honors, I would like to present the procedural background of this matter.
But sorry, Ms. Matut. Could we get clear? Is it not the fact that the other side very strongly objects to that statement?
Which statement, Your Honor? That this is a claim?
An assessment on the Land Acquisition Act and not compensation under Section 17 of the Constitution?
Your Honor, that is not my understanding, and based on at least from what the minority decision had highlighted, and if I could take Your Honor to it continues at paragraph 39, and it continues on the next page, which is page 26. Minority
Miss
has,
Matute, you were reading from the judgment, right?
yes, I am reading from the judgment,
Right.
Your
But
Honor.
all right, so but this was a claim brought, and Justice Arana entered an order. What was the claimant's claim for? Because this was an order in default of something, is that right?
It is
This
an
is a
application. It is an order that was made on an application for judgment on admissions, Your Honor.
All right, good.
Yes.
So so let's start at the very beginning. It's good to start every story at the very beginning, right? You know, so right. Okay, good. So the claim by the claimants was under what? Was it under the LAA or under the Constitution?
No, Your Honor, and that is where I was getting at now in terms of providing to the court the procedural background as to how it is that we are here
good.
now.
Great,
Yes.
good. Thanks.
So I was going to take Your Honors to the fixed date claim form that was actually filed. And I believe this is at page 108 of the record.
What's the date of that document as you tell us about it, Ms. Matute? Give us the date.
It is dated the 13th of December, 2019. Yes.
Thank you.
So the fixed date claim that was filed, if Your Honors take a look at the number 1 relief that is being sought, it says that the respondent is actually seeking damages for violation of the claimant's rights under Section 17 of the Belize Constitution to protection from deprivation of its property, except by or under law by the unlawful taking of approximately 1.35 acres of the claimant's property. In response to this fixed date claim form, Your Honors, an affidavit was filed on behalf of the appellants. And in that affidavit, there were certain admissions that would have been made by the appellants. I do apologize. And one of those admissions would have been the compulsory acquisition of the respondent's property. And this would have occurred in February of 2007. And in addition to that admission being made, there was the admission that the government was in fact ready and prepared to establish the Land Assessment Board in order to make a determination of what would have been the just compensation that would have been due to the respondent. Your Honor, and it is upon these admissions that would have been made in this affidavit in defense of the claim that would have been filed that there was an application for judgment on admissions.
So let's pause. At the time, the assessment board had not been appointed.
Established. It was not established.
And it is under the LAA. You need that board in order to do the assessments.
Yes, once
and
there is
was the claimant right? So was the claimant's claim that one of the breaches of the Constitution was the failure to appoint or to establish a board to assess?
No, Your Honor. The basis of the claim, as I understood, based on what is in the claim form, is that the respondent was saying that the government did not comply with the process under the Land Assessment Board.
Okay.
I'm sorry, under the Land Assessment or Land Acquisition Public Purposes Act in acquiring the property from the respondent. And we contended
there was no admission on that, was there?
We contended that there was in fact compliance with the provisions under the Act in order to compulsory acquire the property. And that is where I was going to get at in the application for the judgment on admissions, because therein it is actually premised on the contention that would have been made by the appellants that the government had in fact compulsory acquired the property. And so on that basis, it was the position of the appellants that the claim was no longer a claim for unlawful deprivation of property.
Ms. Matute, I have looked at the appellants, the respondent submissions, and they are very resolute that it was a wrong determination made that this was an LAA application. They say that that submission, that finding by the trial judge was wrong.
Your Honor, if I may, based on the notice of appeal that would have been filed, the respondent did not take issue with that procedure to have been adopted in the proceedings.
But they don't need to. They need to object to the judgment on a whole, not the basis upon which it was granted.
Your Honors, and the extent we would say of the challenge to this decision would have been the actual assessment that would have been conducted in terms of accepting the appellant's expert as opposed to the experts that would have been presented on behalf of the respondent. And so that is the extent of the challenge, not to say that the applicable principles were not that were applied by the learned trial judge.
Ms. Matut, I will not engage you further. I'll just tell you very, very clearly that I have it perfectly clear that this was a claim under Section 17 of the Constitution, and that any order for assessment had to be an assessment for the damages under Section 17. But if you think I'm wrong, then you can proceed accordingly, and I will hold it open to be persuaded that I am wrong.
Just to understand you, Ms. Matut, you're saying that the government concedes, of course, that it acquired compulsorily the property we are speaking of, and that it acted pursuant to its powers given it by the Constitution of Belize, which resulted, I assume, in the land vesting in the Government of Belize. And the only matter that's outstanding is the payment of fair compensation for that acquisition. Is that the point you're making?
Yes, Your Honors. And so that is why we're saying that the basis on which the assessment would have proceeded is exactly that, to determine what would have been the just and fair compensation to be paid to the respondent in the circumstances where the property was in fact compulsory acquired by the government.
So this is unlike at least one of the views taken in Belmopan, which was that the acquisition was outside of the constitutionally ordained procedure, which could result theoretically at least in the landowner reclaiming the land. This is something very different. The land is now vested in the Government of Belize, and the only outstanding question is what is the compensation to be paid for that acquisition? Am I right? From your point.
Yes, Your Honor, that is exactly the position that we are hoping that the court will understand. And so, Your Honor, we
Ms. Matut,
yeah.
can I just, as you wrap that part up, can I ask, would the compensation be different under Section 17 than if it were purely under the Land Acquisition Act?
Your Honors, I cannot say that it would be distinct. What would make it distinct is the manner in which the property would have been acquired by the government. Say if it was acquired lawfully or unlawfully. That would make the distinction in terms of the assessment of damages that would be payable.
Yeah, so let's say the property was acquired lawfully by the government. Would it make a difference in the assessment of the compensation by a trial judge? That the claim was brought and the admissions were made under Section 17, pursuant to Section 17, as against the LAA. I don't know why, perhaps I'm wrong, but I always saw that there was a connection between the two, that one did not go outside of the other, but perhaps you could assist.
Your Honor, you are correct in that regard, because what we are required to do both under the LAA as well as the Constitution is in fact to provide compensation, and that compensation will be based on the market value of the property.
Thank you. You may proceed. Yes.
Yes, Your Honors. And so, because of the application itself and the premise on which the application would have been made, Your Honors, and we say that the appellants in the case did not take any objection to the application for the judgment on admission, that it was then ordered that the government would then pay full and fair compensation to the respondent for her property.
You're saying that is the order of Justice Arana?
Yes, that is correct.
That's what she said?
Yes, that is correct, Your Honor. And a part of the order was that the parties were to go to mediation, and if we were unsuccessful at mediation, then the matter would have proceeded pursuant to Part 16 of the Civil Procedure Rules, which deals with assessment of damages. Having regard for that, Your Honors, it is the submissions of the appellants that the issue was no longer one under the Constitution. And I know, Justice Barrow, you have your position on this, but it was really an assessment of damages pursuant to the Land Acquisition Public Purposes Act. And we say that this is evidenced by the applications themselves that were actually filed on behalf of the respondent, in which the grounds of those applications were that they proceeded for the determination of compensation that would have been due to the respondent. Your Honors, and we would ask that you take note of the applications, or at least the grounds of those applications. One is at page 240 of 251 of the record, and the other is at page 470 of 1174 of the record.
Could you just give those pages again, please?
The first reference would be the application for the appointment of the experts on behalf of the respondent, and this is at page 240 of page 251 of the record. And the other application or affidavit in support is that of the respondent herself, and this is at page 470 of 1174 of the record.
Thank you.
Much obliged. Your Honors, we would also ask that the court takes note of the decision of the minority that the respondent did not have an issue upon the basis that the assessment proceeded. And as I had indicated earlier to Justice Barrow, based on the notice of appeal that would have been filed on behalf of the respondent in the court below, there was no indication that the that the respondent had an issue in terms of the procedure on which the assessment was done, and was in fact based specifically in reference to the choosing of the reports or one valuation expert over the other. So, Your Honors, it is a respectful submission of the appellant that in spite of the matter having proceeded based on the determination for compensation pursuant to the Land Acquisition Public Purposes Act, it is respectfully submitted that the Court of Appeal exercised its jurisdiction inappropriately in the circumstances where it sought to fashion a remedy consistent with what this court has established that Section 20 of the Constitution allows it to do, to order that there be a reassessment of the market value of the property, as well as that there be a reassessment of the loss of opportunity that would have been put forward by the respondent.
So, Ms. Matute, pause. So you say that that was an error by the Court of Appeal because this was an assessment. You start by saying both under the LA and the Constitution, the compensation is based on market value. But you are saying that the Court of Appeal was in error because the remedy it fashioned was a remedy under Section 20 of the Constitution. Yes? That's what you're saying?
Yes,
Yeah,
Your Honor,
okay,
to the
right.
extent that they have ordered that there be a reassessment in respect of the damages that would have been awarded by the trial judge.
Right. So
that order was wrong? It was wrong for them to order the reassessment?
Your Honor, that is our position, that the Court of Appeal, the majority, would have been wrong in making that order because of the manner in which the assessment was done. And we also submit, and this would be for our other submissions, the evidence that would have been presented to the trial judge and
No,
the
all right. So
credibility
I
and reliability.
just want to clarify something. I understand that point. So are you therefore saying that the Court of Appeal, acting properly, was bound to choose between the evidence presented by the respondent, the respondent's valuation, between that and the evidence of your client's valuation? In other words, the Court of Appeal had no, it seems, power or jurisdiction because of what you're trying to set up to order a reassessment. So if the Court of Appeal determined that Justice James had been in error, yes, suppose they had, and it was you agreed it was within their remit to conclude that. Would you agree with that? I'm not saying that you agree that they should have, but that was within their remit.
Yes, Your
Okay.
Honor, we agree with that position.
Good. So, but having done that, they did not have the power to order reassessment. That's what you're saying. Agreed?
Your Honor, based on the circumstances of
Yeah,
this
no,
case, yes,
yeah, I
that is
understand
what we're
that.
saying. yes.
Sorry,
So, all right.
sorry, and to continue as my brother is asking, you are saying they should have chosen between the two experts. The Court of Appeal should have chosen between the two experts.
Your
Or
Honor,
should have decided on the basis of the evidence of the two experts. That's what you're saying?
Your Honor, to an extent, yes, that is what we are saying, but I would like to qualify the position because based on the circumstances of this particular case, there were in fact challenges with the evidence that would have been presented on behalf of the respondent. And so it would have been for that reason that we would say that in the circumstances that the Court of Appeal ought to have simply accepted the position taken by the learned trial judge in the proceedings.
No. Before we reach there, we understand that's your end position. We're trying to work out a sort of a method that you are suggesting to us. The Court of Appeal is reviewing the decision of Justice James, and they had to determine whether they agreed or disagreed, and whether, if they disagreed, there was a sufficient error of law or fact for them to interfere. We know those principles, right? Just go along with the hypothetical. They decide that there were material errors, either in assessments and or interpretation, and that therefore they could interfere. All right? You with me, Ms. Madhu?
Yes, Your Honor, I am.
All right. I know what your preferred outcome by them is, but what I'm trying to understand as a method, because you say they should not have ordered and could not have ordered a reassessment. So what Justice Barrow has asked, and what I am trying to ask is it then your position that they were bound to make a choice on the totality of the evidence before them from the evaluators? How do you formulate what they should have done? Forget about what outcome you desire. Just formulate what you say they should have done.
Your Honor, I accept the position that this court has already adopted in the Belmopan land development case, where there was a challenge in the expert reports that would have been presented to the court. And so I cannot shy away from that position. And I would say that, yes, it is within the remit of the court to have determined whether on the facts of the case, and we're talking about a hypothetical case, that they would need to order a reassessment in order to make a determination of what is just and fair to be compensated in the circumstances.
So, Ms. Matthew, just to get that clear, you're saying that they have the power to do it. Because I thought at one stage you were saying they did not have the power, but they do. So we can take that off the table. Thank you.
Yes, Your Honor.
Okay, thank you very much.
Sorry. I think my colleagues are satisfied, but I just need a bit of clarity. The Court of Appeal having decided the High Court decision was wrong. What do you say on that premise? Not that you accept the validity of the premise, but on that premise, what do you say they should have done? Order the reassessment or not?
It's hard for me to say, Your Honor, and I can't take away the facts of this case from my mind. And particularly, my main issue would be in respect to the loss of opportunity.
I know that loss of opportunity thing very well. I want to deal fully with it because anyway, but leave aside loss of opportunity. Leave out loss of opportunity for the moment. If the loss of opportunity was not a factor, what do you think they should have done? What do you say? They having come to this decision, High Court decision in relation to preferring Castillo over Gardner was wrong. What should the Court of Appeal have ordered?
Your Honors, as I indicated, I cannot shy away from the fact that the court would be in a position to order a reassessment in order to determine the market value. I cannot shy away.
Reassessment was open to them.
It
Next
was
question, because I will ask the other side. Why was it not open to them? Unlike Belmopan lands, where there was a question as to the appropriate valuation of mixed-use land, agricultural land, city expansion, etc., there was in this case not any of those complications. So it was simply a question as to what comparator provided should have been the valuation of the land. Why was it not open to the Court of Appeal to themselves have decided, based on the evidence before them, what value to put on the land?
Your Honors, as we have submitted in our submissions, there is a process in which the court is able to make a determination of what would be the appropriate valuation to be utilized in the circumstances of a case where there is the issue of compensation to be paid for land. And Your Honors, what has been established is that the court has to be guided as to whether in fact there was some serious error that would have occurred in making that determination as to the appropriate valuer that would be utilized or accepted by the court in making that determination. And in the face of the facts of this matter, we respectfully submit that there was nothing suggestive, at least in respect of the appellant's expert, that would have cause for there to be any questions that goes to the credibility and the reliability of that evidence.
No, Ms. Matus, no. We are at the point where the Court of Appeal has decided that Justice James's preference of Castillo was wrong. The Court of Appeal is now left to do something. Order a reassessment is one something. I'm asking if there is the other something available to them on the facts of this case, which is for them themselves to have made the determination of value based on the evidence before them. They had the comparators, they had the use of the land, etc. Was there anything which stopped them from themselves making the valuation? That's all I want from you.
Your Honor, it's based on what the Court of Appeal would have represented is that there were some, or in fact that the judge would have been outrightly wrong in rejecting, and the Court of Appeal said that this was inconsistent with the principles that would have been established, where it is that you're not supposed to just reject one valuation as or opposed to the other.
Forget all of that. Tell me what the Court of Appeal should have done in the circumstances. We know reassessment is one route open to them. I'm trying to find out if there was the other route, which is for them to have made the valuation. That's all. I want your view on it.
Yes, Your Honor, that is the position that we would put forward, that there was sufficient evidence for the Court of Appeal to have made a determination. And this would have been based on the fact that the trial judge would have found that the evidence presented on behalf of the appellant was in fact reliable.
I suppose, Ms. Matut, you moved along to the proof of your appeal, but in theory, your position, I should be very clear on the record, your position is, because at first you resisted and criticized the order for reassessment. Then you conceded that they could do it. So we passed that stage. You are now saying that on the evidence before them, they could have made a choice as to an appropriate valuation for market value. Agreed? Your preference is one. Do you agree that a court of appeal, or this court can choose your preferred valuation or the other valuation that has been placed before the court? I'm just on the theory of it, not which preference you want us to exercise. We know which preference you want us to exercise. Because if you argue that they can choose your valuation, then surely they can also choose an alternative valuation of that evidence before them. So that's what I just want for the record. Could the Court of Appeal, apart from reassessment, have chosen an appropriate valuation of market value on the evidence before them, which included your valuation or valuator's evidence and the other side's valuation and valuator's evidence? Would you agree that that was theoretically open to the Court of Appeal?
Yes, I would respectfully submit that that was open to the court to assist in its determination.
Great. Pause. Now, now that we've reached out, this is the question I really want to ask you. Given what you took us through with the procedural history and your critique of, you said the Court of Appeal was wrong because it tried to fashion a remedy under Section 20 of the Constitution and to order a reassessment. So you are criticizing that. You accept they could have done it, but you're criticizing it. So you want to take that off the table. Is it therefore your position that what the Court of Appeal should have done was chosen on the evidence before it what was a fair and just market value for the land that the state compulsory acquired?
Your Honor, it is the respectful submission that we would have wanted the Court of Appeal to accept the findings of the learned trial judge. In regard to accepting...
You're not, I know that. We all know that.
You can, Ms. Matut, you can take it that we all know it resoundingly.
But
you will not shift from that. But please answer my brother's
I'm not inviting you to shift. I'm just asking you, this is not to put you in a corner. It's to understand something theoretically. Because you see, you have taken reassessment off the table. That's your preference. So then I'm just trying to get on the record. Is it then that your position is the Court of Appeal in this case should have made a choice? We know what choice you want them to make, but before we reach that they should have made a choice and a decision on the evidence as to fair market value. Is that your case?
Yes, Your Honor, that is
good.
The case.
That's what I want to ask. Thank you. Now you can tell us why we choose you.
Mrs. Matut Tucker, I gather that your case is that the Court of Appeal ought to have upheld Justice James in his opinion. And he gave, I think, 5 reasons why he rejected the evaluation of Mr. Gardner. But the Court of Appeal dealt with all 5 reasons and were not obviously convinced by them. So would you be interested in telling us why you think the Court of Appeal erred, why you thought that the trial judge was right to reject the valuation by Mr. Gardner?
Yes, Your Honor, I would happily assist the court in explaining why it is that the trial judge would have been correct in rejecting, the report of Mr. Gardner. And we say that based on what would have been presented by Mr. Gardner, that it satisfied the requirements that would have been established by this court in Belmopan land development, where it is that the expert would have proceeded on a faulty premise or would have taken into account irrelevant considerations in reaching the conclusion that the expert would have reached.
One of the reasons given by the learned trial judge for rejecting the report of Mr. Gardner had to do with the comparator, the
Yes,
person.
the outlier. There was an outlier, and based on the evidence that would have been presented to the court, it is the position, I believe, of the Court of Appeal that it was uncontroverted that this property would have been a respective comparable in terms of it being an undeveloped property being closest to the property or the subject property. But it was the position that, at least based on the evidence that would have been provided by the defendants, that was in fact not the case. And in fact, the property would have been a developed property, and that there was no explanation given as to the high value that would have been attached to that property as opposed to the other comparables that would have been utilized.
One of the reasons the judge rejecting, this comparator was that he thought there was no evidence that it was undeveloped land, and therefore it wasn't a true comparison.
Yeah.
But the Court of Appeal says that there is no dispute that it was in fact undeveloped, and there are aerial photographs to show that it was undeveloped. So how do you reconcile that?
Your Honor, there was cross-examination of Mr. Gardner in respect of that, and I know the Court of Appeal had indicated that and at least from when we were doing the appeal, that the judge indicated that I had not put it to Mr. Gardner that the property was in fact undeveloped. However, when it is that Mr. Castillo would have been cross-examined and the same issue would have been put to him, he in fact had indicated that the property was in fact undeveloped. And in respect of the pictures or aerials that would have been provided by Mr. Gardner in respect of the property, there was questions put to him in order to determine the exact date on which these images would have been produced.
Yes.
So let me see if sorry, go ahead.
Yeah, I'm sorry, President. Please go ahead.
Yeah, on this issue, I'm not clear. Is there a finding of fact that at the time when the comparator, which they say was an outlier, when it was valued, when it was sold, that it was undeveloped at the time? Is there a finding of fact on that issue?
No, Your Honor, and that is what we're saying, is that the court did not accept that it was undeveloped.
So the judge's view that it was or may have been developed at the time when it was sold, that has not been rejected?
Safe to say that the respondents say that the property was in fact undeveloped, and that would have been through the expert. There were no other suggestions that it was a developed property.
So the judge said in his judgment that there was no evidence it was undeveloped. So was that not an error on the part of the judge?
Respectfully, Your Honor, we would say that it was not an error because the property was in fact a developed property at the point of sale.
What is the evidence of that? What is the evidence that it was a developed property at the time of the sale?
And this was generated under cross-examination of Mr. Castillo, who would have indicated that the property was a developed property, and that is why he did not utilize it as a comparable when he prepared his valuation report.
But Ms. Matut, apart from his say so, he said so, but he didn't go to the land in 2007. What evidence, what is the comparable evidence in this case to support one position or the next? Because the other side's valuator said something different, didn't they?
Yes, Your Honor.
Right. So we have hard swearing, two valuators. The say so of one now is that it was not even no evidence that it was undeveloped, but positive evidence that it was developed. That's what you are saying. Castillo has positive evidence it's developed, and the other valuator says it is undeveloped. Was there any independent evidence that we could say is reliable that could have resolved this hard swearing dispute?
No, Your Honor, respectfully, there was no other evidence that
The
would have
aerial
shown.
photographs don't qualify. The
There
aerial
were
photographs.
challenges to the aerial photographs to suggest that they were not a true representation of the state of the property.
Was
at
that
the
put to
time.
Mr. Gardner?
Yes,
that
it
put-
was. If
put
I'm
to
not
Mr. Gardner?
mistaken, yes, Your Honor, if I may.
Please. Let me tell you, Ms. Matut, what this engages in my mind. This engages a statement being made to Gardner that you are coming here and falsifying evidence. You are presenting to this court a document which you claim to be something, and that is false. It's a
Ms. Matuk,
strong
we're not here. Yeah, sorry.
accusation.
Yes. I'm sorry, Ms. Matuk, we're not hearing you, but
I think she's looking for.
I'm looking in the
yes.
transcript to
For the yes. Was there a date on the aerial photographs and
No, there was
certified
not.
by
There was
the director of surveys or an equivalent in
I think it would have, my sister, I think it would have been a Google map.
Yes,
Or
Only
that's what it
aerial.
was.
so it wasn't the old aerial photographs that we know of,
No,
which are
No.
government documents.
no.
Your Honor, if I may take you to page 529 of the record. So specifically, so the conversation in respect of the Google images starts at page 529 of the record.
Tell me what it
But
says.
It's the start of the conversation, but I want to take Your Honors specifically to page 531. And the first cue, it's Mr. Gardner, can you tell this court when this image was generated? And his response is, at the time I did the valuation, of course. And the next question was, is there any date on this document to say? And his response was, I don't think there is. And we were having some technical issues, and so I did not hear him.
Pause. Let's just pause. Let's just fill in some gaps here. In cross-examination, he says that the image was generated at the time he did the valuation. Yes?
Yes.
And when was that? That is to say, when did he do his valuation? Was it after the sale?
Your Honor,
you ask a question in cross-examination, you get an answer. If you don't call evidence to rebut it, then you are bound by the answer. That's the rule, right?
Yes.
Right. So he says the image was generated. You ask the question. We know what people say about what you do and shouldn't do when you ask questions in cross-examination, but you ask the question and the answer you get is the image is generated at the time I did the valuation. When was that before or after the sale? I.e., did he do his valuation before or after the sale?
The sale.
We have a valuation report, Ms. Matuk, of the 21st of February 2019. Is that what he's speaking about, or is another valuation?
It would be that valuation, Your Honor. That is where I'm trying to get at.
Let's get something clear here. I think you and I both know that at the time I can do a Google map search and I can have it show me what an area looked like in 2007, can't I?
Yes.
So the question was never asked of him, or suggestion made to him that this is not image of the property at the time. It was sold.
I continued, Your Honor, with the questions to him in respect of the Google images.
Right.
So I had put it to him that the image for the property, and this would be the outlier property that he indicated would have been, that it could have been generated in 2006, and this would have been before the compulsory acquisition of the property.
Right. Right.
And he said it may have been possible that Google might have had something up in 2006, but I'm sure it would not look like this.
That's the answer you got. Are we all bound by that answer? Did you call any positive evidence to rebut what? We can all read the transcript and see what he said. Did you call any rebuttal evidence to demonstrate positively that these Google images that he is saying show the state of the land in 2007 are inaccurate, misleading, erroneous, and to positively show on your case, as your evaluator asserted, that in 2000, I'm saying 2007, I think it was 2006, that in 2006, the land was developed. The Google images, let me just ask a straightforward question. Did the Google images show the land as developed or undeveloped?
Based on what Mr. Gardner had presented, it showed the property as being undeveloped.
Undeveloped, all right.
Yes. And
so your case on this vital point was that the land was developed. That's your expert's evidence.
Yes, and that is why it would not have been utilized in...
I understand that. I am understanding that. So you get in cross-examination a response that is not favorable to you because he says, hardly likely. You have an opportunity to seek leave to call rebuttal evidence on this, to contradict this and show either the error in what his evidence is, the accuracy of Google Maps in 2006. Did you do anything like that?
No, Your Honors.
So we are left with the answers you got in cross-examination as uncontradicted, and you are bound by them and we are bound by them. Agreed? As a matter of law.
Yes, Your Honor.
All right, good.
It goes further, Ms. Matu, doesn't it? It goes further. Mr. Castillo testified after Mr. Gardner, didn't he?
Yes, he did.
So it was open to the government to ask Mr. Castillo, did you, Mr. Castillo, go and do at any stage a Google map search or a Google image search to see the state of this property in 2007 or 2008 when it was sold? Correct?
It could, yes, we could
so
have
that
asked
is
that
the
question,
contradiction
however,
that my brother is saying was not forthcoming. Therefore, when the Court of Appeal, Justice Foster said that even I can see this was undeveloped land by looking at the Google image, there was not anything to tell him that you are looking at a false or erroneous image. Yeah?
Yes, Your Honor.
You know, Ms. Matuk, I'll tell you that in case in Trinidad, Justice Rajatni will know it well. It's called Mack versus Passad. And two of the great titans of advocacy in Trinidad, Tajmul Hussain and Michael de Labastide, contested that case. And the case was determined on a single fact about the making of a telephone call. And it went all the way and it was resolved on whether or not rebuttal evidence as to whether a call was made or not made had been made. And it establishes, not the question, the facts are no less important. It establishes what Justice Barrow has been chatting about, the rules of evidence that bind us when these sort of matters arise. It is well worth reading Mack and Passad. Justice Rajatni is is closer to that than I am, and she may add to it, but that is certainly my recollection.
Ms. Matuk, something that occurred to me earlier, and I think Justice Jamada's very relevant comments caused me to go back. In the light of all that we've discussed so far, do you understand the basis on which the majority of the Court of Appeal thought that they had to send the case back, that there was something missing in the evidence? That's something I've been trying to grapple with since you began this morning. What were they going back down to do?
My understanding of what the Court of Appeal had found is that the learned trial judge was wrong to accept one valuer over the other. And based on that finding, that is why the Court of Appeal has ordered that there be a reassessment, because the trial judge would have been wrong in terms of the assessment of the evidence that would have been presented by the expert in respect of the value of land on behalf of the respondents.
But Ms. Matuk, they were not just saying that, they were saying further expert evidence. That's the impression I get reading the judgment of Justice Appeal Foster. I mean, you were in the court, so you will understand the context of that statement. What was there left to be got?
Your Honor, my understanding was that the Court of Appeal was adopting a position that this court would have adopted in the Belmopan land development, where there were gaps in the expert evidence that would have been provided to the court. And so the court would not be in a position in order to make a determination based on what is before it as to the market value and the compensation that should be paid.
May I offer you a supplement to your answer? Which is that the Court of Appeal saw the absence of evidence in relation to inability to develop the land as a major stumbling block in their determination of this case. The trial judge rejected the testimony of Mr. what's his name?
Lopez.
Mr. Lopez, as to valuation of inability to develop the land, and they therefore sent it back for that evidence to be had. Is that not the primary reason you think why there was a need for further evidence in the view of the Court of Appeal?
Respectfully, Your Honor, I do not agree with that. I think that is a separate issue that the court had to consider based on what would have been put forward by the respondent in that regard.
Okay. But they sent it back for that reason as well?
Yes, they did, Your Honor.
Okay.
Your time is running out, Ms. Matute. You want us to quash the Court of Appeal's decision, to reverse the Court of Appeal's decision, and to uphold the trial judge's decision. And the basis on which you want us to do that is what, very succinctly?
Is the evidence that would have been presented on behalf of the experts for the respondent being unreliable and lacking credibility for the court to have made a determination.
I think you have been almost compelled to concede that on the issue of the comparator not being undeveloped land, that the trial judge may have made a material error there. Well, let's not go through that again, but clearly that appears to be the case. The manner in which the Court of Appeal subjected what the trial judge, what the evidence of the landowner and the trial judge's decision to uphold that evidence. The manner in which the Court of Appeal subjected that to an examination, was that same examination done of the evidence that was presented by the landowner?
No, there was no subjection to the extent of the experts as that of the landowner. And in the case of Mr. Lopez, he had undergone extensive cross-examination. in which he was determined to be an unreliable witness in offering the evidence that would have been necessary for the court to have made a determination in respect of the inability to develop the property.
So the Court of Appeal gave any assessment of its view of the evidence that was presented by the landowner?
The landowner herself, no. Regard would have been had for the expert evidence.
Or the evidence of the landowner's expert?
Yes.
And how would you sum up that assessment by the Court of Appeal?
That they found that it would have been reliable to the extent that the learned trial judge ought to have considered what would have been presented. And it is, of course, our position that the learned trial judge was correct to find that the evidence was not reliable or was not credible in order to make a determination, and so accepted what would have been presented by the appellant in regard to the market value, and therefore awarding nominal damage in respect of the loss of opportunity to develop.
Just to follow up on that, did they also subject the evidence by Mr. Castello to that searching examination?
Your Honor, not that I am aware. The extent of what the Court of Appeal would have highlighted was that the learned trial judge would have accepted one evidence over the other, and that there were some inconsistencies, and the court ought to have considered those inconsistencies in light of what would have been presented by the respondent.
What I'm trying to get at is, did they find fault, and to what extent if they did, with the evidence of the valuation presented by Mr. Castello?
Your Honor, like I indicated, the Court of Appeal was of the view that the learned trial judge did not apply the necessary principles in determining what would have been the appropriate valuation to accept. That's my understanding. And so it's not necessarily to say that there was any issues in terms of what would have been presented by the expert on behalf of the appellants, but to say that, well, one was chosen over the other and the court was wrong to have done that.
Yeah, I follow. One very peripheral point, and it may be completely irrelevant to all of this, and you may not know the answer, and that's fine if you don't. Do you know how much was paid for the land by the landowner prior to compulsory acquisition?
No, Your Honor, and that evidence is not before the court either.
I thought I read something of relevance in the transcript, but I may have been wrong. Thank you. Sorry to interrupt you, President.
Yeah, no, that's fine. Just following up on that, there was also, I think, in Mr. Gardner's evidence, some mention made that the landowner had concluded or was about to conclude or was in negotiation to sell the property that was acquired. Do you recall that?
No, Your Honor. I will hurry look at the reports.
If you don't, because it would be something that I'm sure would have caught your attention. So maybe I was mistaken, or it's not something which was.
I don't recall, Your Honor. I honestly don't recall.
Yeah. Okay.
Perhaps, President, when she comes back to us at the end, she could let us know. Thanks.
Is there anything that you wish to emphasize to us why we should allow the appeal that you haven't already touched on?
No, Your Honor. I think I have touched on all the necessary points for the court to consider.
And argue them quite resolutely.
I try.
Yes,
I recall a former leader of yours.
Yes.
And Ms. Matut, we appreciate your assistance, to be very clear about it. We really do. Thank you.
Thank you, Your Honor.
Yes. Okay, thank you very much, Ms. Matut. Mr. Smith?
You are muted, Mr. Smith.
Can you hear me now, Mr. President?
Yes, we are.
Yes. I was going to say that I'll try to lay out in my submissions the points as succinctly as I could, And I'm wondering if there is any specific aspect coming out of the exchange with Ms. Matut that the court would wish me to address.
Would you agree with Mrs. Matut Tucker's characterization that the Court of Appeal was not concerned directly to identify weaknesses in the valuation report submitted on behalf of the government? Rather, their concern was that the methodology of looking at both reports and taking them both into consideration was not followed. And there was no good reason given by the judge as to why he was prepared to ignore or discard one of those valuations, namely that of Mr. Gardner. Would you agree that that is what it comes down to in terms of the decision of the Court of Appeal?
Yes, and much to my great disappointment, because I had laid out extensively in my written submissions and oral submissions to the Court of Appeal why reliance or why preferring Mr. Castillo's valuation was faulty. But yes, the short answer is yes, the Court of Appeal did not engage in any deconstruction or assessment or analysis of the strength or weakness of Castillo's valuation on behalf of the government.
Well, given that that evaluation was the one accepted by the trial judge, and that they are now to overturn, as they have decided to do, that decision, would you have thought that that is something that they should have engaged in?
Well, my understanding of I would have preferred to have seen that to make it more comprehensive. The majority appeared to have taken the view that the trial judge made a cardinal error in simply preferring one over the next, and then in engaging in an exercise as to why the 5 reasons put forward by the trial judge for not accepting Gardner was in fact wrong. But yes, for completeness, I think the Court of Appeal ought to have engaged in an analysis.
Well, you say for completeness, but isn't it a cardinal rule that if you're overturning the trial judge, you ought to identify, well, I suppose you could say you ought to identify the errors which are patent in relation to the evidence that he's relying on and the evidence which has persuaded him. I would have thought that that is...
Well, you know, Justice Anderson, some courts take the view that certain issues are dispositive of an appeal. And in this case, it appears that the Court of Appeal took the view that the trial judge rejected Gardner's evidence. None of the 5 reasons advanced could hold water. The trial judge simply then took the evaluation in total of the other valuator, and that for them it appears they came to the view that it was open to them to use that as being dispositive of the appeal. As I said, for completeness, if I were involved, would have wished to see, I would have dealt with the valuation of Castillo, which I have advanced a number of reasons in the written submissions before you, why it was entirely unsafe to rely on Castillo's valuation as being representative of true market value of the subject property.
Now, could you just give us the highlights, just 2 or 3 minutes as to those main reasons, please?
Yes, I would like to flag up 6. The first one goes to we say, there is a pall of suspicion over the integrity of Castillo's report. Why? A reading of the record and the transcript will show that he had two valuations, one dated in 2020, one dated in 2021, virtually identical. In the first one, he noted in two places that he was rushed. He didn't have the opportunity to do a physical inspection. A physical inspection was necessary. Not enough research was done. 1 year later, there appears a second valuation, identical in all material particulars, except that notation is removed and he included an amount for landfill. It was put to him in cross-examination that it was a cut and paste job. He never really did any physical inspection. He maintained his position that he did. However, when asked on the cross-examination, if you did a physical inspection the second time around, would land appreciate? He said yes. Why did you not, he was asked, include even a marginal sum for appreciation? His response was, my instructions was that I was not to put the present value. I therefore say, or we submit respectfully, that casts a pall of suspicion over the integrity.
Why was he instructed not to put the present value? Was that because the valuation was to be done effective at the date of the compulsory acquisition?
No, but the value that was his first one had 2020. He had no difficulty with it being the present value then. So when caught on the cross-examination as to why there wasn't even a marginal increase, if, as he conceded, land appreciates, he retreated to say, well, I was instructed not to put the present value, which creates a bit of an anomaly. And so I say it creates some suspicion.
But that's number one.
That's number one. Number two is the fact that even if you accept that he did a physical inspection, the physical inspection was faulty or defective or tainted, because on the cross-examination, he admitted that he was obliged to measure distances of comparators to the subject property, and he never did so. He admitted that on the cross-examination. Thirdly, he adopted the sales comparison approach, which involves sales. You will see in his valuation report that the sales comparison approach involves inspecting similar properties in close proximity to the subject property. He admitted on the cross-examination that of the 5 he looked at, 1 wasn't even on the water side as the subject property was. 3 others were not in the immediate vicinity. When asked about 46 parcel 4633, which was the one Gardner relied upon, he simply said, well, I didn't think it was a true comparator because it wasn't developed. And he was asked on the cross-examination, aren't you aware of the evidential rule, the procedural rule, that even if a valuation or even if there's a piece of evidence that contradicts your finding, you're bound to disclose it? He said he wasn't aware of that. So that's the third item.
But just to be clear on that third one, how many of the properties that he looked at were on the waterfront?
None.
Sorry,
None
one.
Sorry?
One, he said.
Yes, there was one. In fact, it was the same one. He and Gardner and Castillo each relied on one of the comparators that Castillo used.
Okay, but the others were not on the water.
The others were not. Fort Castillo made no attempt.
Mr. Smith, just as a matter of interest, that one property that they both relied on, did they agree on valuation, or did they do? If he used his sales model, they use the consideration. Then is that what they did? I'm just trying to understand if we have at least one agreed overlap. Where were they on that? Yeah.
I don't have the answer, Judge. Regrettably, I'd have to go back quickly and check, but I don't have it.
I don't know that Gardner gave values for the other properties which he identified as comparables. Castillo did in his table. I don't recall that Gardner did so for those which he identified as being in the area.
Okay.
I think in relation to that, the court might want to look at Mr. Gardner's 12 comparators, which can be found in a table. I hope I get the page number, the pagination correct. Page 292 says in what I have in front of me, and this was attached to an affidavit of Gardner, and it has a list headed Caribbean Shores Sales Data, 12 comparators. But if I might conclude, Justice Anderson's, the fourth was hope value, the failure to include even hope value, developmental value, nothing at all. He just did a straight sales comparison. This is what similar properties sold for with no hope value. And lastly, even the trial judge described Mr. Castillo, the government's valuer, even characterized his valuation as weird, W-E-I-R-D, weird.
Did he say why?
He did not say why. I will take the court to it very quickly. It's in the transcript of the High Court proceedings. And in fact, it's the very last page.
What paragraph of the judge's judgment?
921. It's not the judgment, it's the transcript.
Ah, okay, right.
Proceedings.
Sorry, what page again?
921. And sorry, the exact words when he addressed learned assistant Solicitor General Ms. Matute and said, Ms. Matute, I do think a million sounds a little weird too. I'm just saying. So that those elements taken together.
But hold on. Did he not order the 1 million?
Yes. The point is, Mr. Justice Anderson asked me.
Yes. Point
yes. So he took it in total without any attempt to make any discount adjustments up or down as Holiday Lands suggests one ought to do, so that in sum, because of those factors, we say that it was entirely and is entirely unsafe to rely on Castillo's valuation as being representative of true market.
I understand you fully, and thank you for that very comprehensive answer. Am I right in thinking that the land was compulsorily acquired a year and like 8 months after your client bought it?
Roughly, yes. I think she bought it sometime in 2005, and by 2007, the second publication had been done.
Yes. Again, it's peripheral and perhaps not relevant at all. Can you tell us how much you bought it for?
I'm afraid that I wasn't involved at the trial stage. I only came in on the appeal.
But Mr. Smith, can I ask you that question a different way? Has this formed part of the evidence at all? to your knowledge? The purchase price? Ms. Matut says she does not recall it and doesn't think it did. Do you have any instructions that the purchase price at the time of not compulsory acquisition, at the time your client purchased, has that formed part of this case in any of the evidence or arguments to your recollection?
Not that I have seen.
Yeah. Okay. Good. Thank you.
Yes. Yes. As I said, I did read something in the transcript which came to us, but it could very well be that I misread.
I'm sure it's not. When you say the transcript, do you mean the record, Justice Anderson?
Yes, it came in the record of appeal.
Yes. Certainly not in the transcript because I've spent several hours on the transcript. I can't remember seeing it in the record, but I have to confess that I, of course, haven't read the full record. I only take out the pieces.
But Mr. Smith, maybe I can ask the question a different way. If land is purchased on day X and you prove it is purchased on open market, and then the state acquires it within a year or about a year later, and valuators are coming to do valuations as to fair market value, would that not have been relevant evidence as to the fair market value of the piece, the very subject matter of the assessment? I.e., we have comparators, but look, a year ago, this land was bought and sold on the open market for Y dollars. Would that not have been relevant evidence in determining fair market value? If that was so, I'm just asking.
Yes, it's a relevant question, Justice Jamadar. In this case, the land wasn't acquired. It wasn't one private person to the next. The client, Primrose Gabourel, bought it from the government, and government would not. It's well-known fact, I think, certainly in Belize, I don't know if throughout the Caribbean, that the government doesn't sell land at the same price as you get it on the open market.
Okay, Mr. Smith, there are a couple of things I wanted to get your responses on. You were content with the Court of Appeal's decision. You didn't cross appeal.
No, I didn't cross appeal. No.
So, if this appeal failed, then what?
If this appeal fails, this court is left with the option of.
Sorry, President, could I ask you to repeat? My internet froze while you were speaking.
No, I first of all, I went through with him that there has been no cross appeal here, so we are only concerned with the Court of Appeal having given a decision, and one side is dissatisfied as an appeal. So I've asked him, if the appeal of the side that has appealed fails, then what?
If the appellant's appeal fails, this court can either affirm the judgment of the Court of Appeal, in which case the orders made would consequentially flow, or perhaps this court can decide that it can do the valuations itself.
Okay. And that does not necessarily mean that I agree or accept what you say, but I accept that that is your response. Some issues have arisen in relation to the LAA, Land Acquisition Act, and compensation under the Constitution. There are certain differences in the procedure by which value of land is arrived at under the LAA and under the Constitution. Clearly, under the LAA, you're supposed to set up a board of assessment. There's a process and so on. But nevertheless, the end goal is still the achievement of fair market value. Under the Constitution, you go to a judge and you put forward your evidence and so on, but the end goal is still the market value of the land or the return of the land, if in fact there has not been compulsory acquisition and the land can be returned. Now, in this case, is it your client's view, is it your client's position that this land was compulsorily acquired in 2000 and was it 7 or 8?
7. Yes.
Right. So if that is agreed, then although we don't have the tribunal and the mechanisms that are laid out in the Land Acquisition Act, nevertheless, the land would have been vested in the state from 2008. And therefore, what the landowner is entitled to is the land as valued at 2008 when it was divested of its property, and interest on that amount from that time to the present time. Is that correct?
Yes.
Okay,
Which
so
therefore
that,
brings you squarely to Mr. Gardner's valuation of the land in 2006. Page 141 of the record, where he says that the 2006 value is 4.5.
Without interest.
Correct.
right.
2006 value.
Yes.
Yeah.
Without interest.
Without interest. Yeah.
Yeah.
There was no interest because it was just acquired 2006. Yeah.
Right.
All right. And you, sorry, if we were to accept Gardner's valuation as to be preferred, to be acted upon, you would not have a quarrel with our relying on that figure.
No, I couldn't conceivably have a problem because that's
I thought so too.
Plus interest, of course.
Yes. You have
But
said
no,
that
I
3
don't
times.
know. I mean,
I got you the first time.
You may say between 2006 and 2008 there should be some uplift. I don't know. But for the record, we just want to be very clear. You want no uplift because 2006 is before 2008, right? You and your client are happy to abide the 2006 valuation of Gardner, even though the acquisition was in 2008.
I think, Your Honors, the acquisition was in
2007, wasn't it?
2007.
7. But it's, yeah, okay. But the point is, are you willing to accept the 2006 valuation?
My brother, I can answer for him. He'll say with interest.
Well, the interest follows. We know it's with interest. We on the valuation as market value. Interest is not market value. Are you prepared to accept the 2006 valuation of Gardner for the land at 2006 as a fair and just market value? Don't tell me about interest.
What about the upliftment that you referred to?
Well, that's what I'm asking you. I'm asking you. You have to make a choice now. If you tell me about upliftment, you know what I'm going to ask you?
What are you going
If
to
we
ask?
can't calculate it, then maybe we should send it to work it out. So you choose. This is your
Yes, so
choice to make now.
I think it should include upliftment, but I am not prepared to deal with that error.
So,
And there's no evidence about what uplift should be given. But
No.
it is not inexorable that a 2006 value must be uplifted in 2007. It doesn't follow as night follows day. You know. But anyhow, so that is one thing. There is an issue about, okay, let us assume, just for the sake of argument, that, okay, there's a valuation in 2006 that everybody says, well, okay, that is the only proper value that we can ascribe to the land at around the time it was acquired. So you're entitled to that plus interest. Is there a further issue about development value or hope or any other thing of the like?
Yes, there is the jurisprudence. The learning seems to suggest that a property like this one, which Gardner characterized as the last piece of waterfront property in Belize City, measuring over 1 acre, it would certainly suggest, to use the language of the jurisprudence, that it is dead ripe for development, which is what others call hope value.
Yeah, but that hope value and ripe for development, why is that not taken into account in the value? So, in other words, would that hope value or ripe for development amount vary depending on who is the landowner and what ideas the landowner had for the land? Or isn't the value of the land, an objective figure that is premised on its location and its potentialities, irrespective?
Yes, yes, the answer is yes.
Therefore, Mr. Smith, if I may, Gardner's valuation included the development potential of the land. He's expressly stated various uses to which this land could be given, including water sports, landfill, etc., etc. Therefore, his valuation included development or hope value.
It did.
Good, thanks.
Okay, so...
But President, just be clear, that's not the 4 million valuation. Mr. Smith, I just want to be very clear. Our brother said that Gardner's valuation included the development or hope value. What valuation do you have in your mind when you agreed? What figure you have in your head when you agreed to that?
Well, the figure is the 4 million figure, whatever.
All right, okay. I just want to be clear. The figure in your head that includes the hope or developmental factor is the 4.5 2006 valuation. Is that what you're saying?
Correct.
All right, good.
Yeah. So, okay, it's boiled down to this now. The appellant is saying that they don't like what the Court of Appeal did. They're dissatisfied with the Court of Appeal's judgment. The Court of Appeal should have accepted the respondent's valuation, and they wish this court to reverse the Court of Appeal on that score and to uphold the respondent's valuation. You have not cross-appealed, but from your answers, it suggests to me that you would be satisfied if this court found that Mr. Gardner's valuation should be of the land in or about the time it was acquired, 2006, 2007, should be upheld, and that the court should reject the appeal and vary the Court of Appeal's order to give the respondent the value of the land as given by Gardner in 2006 plus interest. Is that where we are?
Sorry, plus the landfill.
Judge, may I have half a minute to consult my instructing solicitor?
Sure, by all means.
Your Honors,
Your Honors, yes.
thank you very much for your indulgence. And the answer is yes to what
Yes.
Your Honor, President.
Yes. Of course, there's a third option, which is the procedural one that, well, look, given that what is before us is only to reject the Court of Appeal and so affirm the trial judge, or to endorse the Court of Appeal, that we simply endorse the Court of Appeal. But you wouldn't like that.
But before you express a like or dislike, could I just add this as well to it, which is that I wasn't sure I was of the view that the Court of Appeal was necessarily saying that the evaluation by Mr. Gardner was the one to be adopted. As was indicated when we started this conversation, I thought they were saying that the procedure adopted by the trial judge was not the correct one, and that he ought not to have just rejected Mr. Gardner's valuation without more, and he ought to have taken that into hotspot, if you will, whilst he also considered the evaluation given by Mr. Costello. So the third option outlined by the president does have that advantage, whereby the two valuations could be considered, and then a number arrived at. I'm just putting that on the table because, as I said, I could be contradicted, and please feel free to contradict me if I am mistaken in my view. But were they simply saying that they should accept Gardner's valuation to the exclusion of Costello's, or were they saying that the judge was wrong because it simply relied upon one valuation and did not include consideration of the other?
Yes, I think I agree with what you were saying, Justice Anderson. It is not, on my reading of the majority's decision, it is not that they were saying that Gardner's decision valuation was the valuation that should have been gone with. It was, as you say, that the trial judge was wrong to rely solely on the evidence of Castillo, and pointed out the reasons why he was wrong to have rejected the decision of the valuation of God. So yes, I agree with your characterization of that.
Okay. Mr. Smith, in that case, would we be as wrong as the trial judge if we relied solely on one valuation over the next, if we were persuaded that we ought to come to the court with a figure and give the parties that figure as reasonable compensation? Do you think that is the case? And what I have been trying to find out from the start of this morning and from the start of reading these documents, it's why the Court of Appeals thought they needed further evidence. I know there is that area of the right to develop and the profit loss there. But it appeared to me that Justice Foster was saying there are other things that we need. Can you assist me on that? But I'd like an answer to the first question as well.
No, well, obviously, the Caribbean Court of Justice, if it arrives at a figure, would do so based on some reasoning, having analyzed both valuation and having decided with reasons why it is relying on a particular comparator to the neglect or rejection of others, and so on. So it is possible for this court to come to a figure that reflects Gardner's figure, except you would have done so, the court would have done so based on the proper kind of reasoning that should attend the exercise.
But without the benefit of any commentary from the Court of Appeal on Costello's report?
Well, Castillo's report and valuation, and the criticisms I have made on it is
On which there were
under-
no findings by the Court of Appeal.
No. The Court of Appeal itself did not, as we have already discussed
exactly.
it did not do that. But I don't know that it is not open to this court to do so. Based on the valuation, it's before this court. The record is
my sister's second question is still on the table about the additional information that might be required.
I think what Justice Barrow alluded earlier during Ms. Matoot's, my learned friend's presentation, is the only answer that I can think of. I think it was because of the loss of opportunity point, and I think the court was eager to embrace, or certainly the majority in Belmopan case, the majority's view that this being an arbitral type exercise, it was better suited to have a judge and assessors. I think that appears to have resonated the Court of Appeal. But other than that, as I've said in a direct answer, I think from Justice Saunders, the President, or Justice Barrow, it is open to this court to do the exercise, the holiday lands exercise itself.
Mr. Smith,
Yes.
is it not the case that the Court of Appeal failed to advert to the fact that that adopting Gardner's valuation in part or in whole would involve no need to do that assessment of the loss of ability to develop the land, because Gardner's valuation included that element? The Court of Appeal did not advert to the fact that inability to develop the land, which is really the development potential of the land, is included in a proper valuation. It was not included in Castillo's valuation, which is what the trial judge relied upon. It was not included in Castillo's valuation. Therefore, in the trial judge's approach, it had to be separately included. Whereas in Gardner's valuation, landfill was included and development potential was included. Is that not correct?
Right.
Thank you.
You see, I think that it may be that what struck the Court of Appeal is that Mr. Gardner's comparator was, and I think that that is what also struck the trial judge, was so far in excess of other comparators that they were not satisfied that there were cogent enough reasons to explain the difference. But there is evidence that there are reasons that explain that difference. And if those are cogent and full reasons, then I could see where one can say, well, you can accept that it is not an outlier. It really is a good comparator as compared to other comparators that were not good because of X, Y, Z reasons. But certainly one has to consider the reasons, if there are any other reasons, why the Court of Appeal would have decided as they did. Anything else you want to tell us, Mr. Smith?
No, I think that is it in terms of advancing of arguments. But since we are at the apex court, I did wonder about what seems to be developing practice where government acquires land, I believe willfully refuse to put boards of assessment in place, and I say so because there's a number of cases in that regard, and then litigants are obliged to invoke the constitutional process, appearing before a single trial judge, when that was not what was intended.
That's exactly the point. And perhaps the litigants' recourse, the recourse that they've taken is perhaps not the right one. Instead of bringing a constitutional motion, they should bring a mandamus, because the whole constitutional architecture for valuing land that is compulsorily acquired is written out in a statute involving a board of assessment and things that the board must do, and allowing for both the landowner and the government and a neutral judge to be involved in the process. But when the landowner, and this is not to be taken as a criticism, because if you have had your land compulsory acquired or taken away from you and you're not seeing any compensation or anything, then I don't blame you. But when you go to the court on a constitutional motion and ask for constitutional relief, then you trigger a process that, unless the court is astute enough to put you back on a proper track, you trigger a process that results in a judge alone undertaking a process that was really not meant for a judge alone, but was meant for a judge with a person appointed by the landowner and a person appointed by the government, and that has certain rules and procedures in order to arrive at proper compensation. The constitutional route really, I think, should be in a case where you can establish that the land was taken out of spite and not for a public purpose, in which case the remedy is not market value. The remedy is to quash the purported acquisition order and to give back the land to the landowner. You know, but
Yeah.
I agree with you.
Yeah, President, Mr. Smith, this seems very unfortunate that all this time, we're almost 20 years, give a few, 3 years again, from the date that this land was compulsory acquired. And it is just, to me, something must not be right there. Because I look at the Constitution, Section 17 actually seems to indicate that the reasonable compensation should be given within a reasonable time, determined and given within a reasonable time. It cannot be that almost 20 years is a reasonable time. And it is a very, I think I agree with the president completely. The landowner cannot be faulted because they're between a rock and a hard place. The land is already acquired and, you know, they've moved on. And several times landowners rely on the promises of this government official. We get into you now, we're doing this, we're doing that. It's very, very unfortunate because I would think that in a matter like this even, with this length of time having passed, that another court might even be interested to give some sort of damages to show that this should be looked at with some sort of outrage. I really do not think that this should continue if this is what you're saying has been the trend in Belize.
And can I just ask a question arising from that, because I share all of those sentiments. Has a board of assessment been appointed as of today?
You mean?
Can you, has that been, was anybody, Mr. Smith, it doesn't matter, has this tribunal been set up to process, and the rules and regulations, has all of this been done now?
Your Honor, there was one matter which was actually referred to the Land Assessment Board, and the board made a determination. And
So
I
the
Sorry, in
board
this
is, the
case?
board is up and running.
not in this case, in another matter.
Yeah.
I thought the question was a general question.
No, Justice
with respect
Jamal,
to the-
a board of assessment needs to be appointed for each individual case.
Yes, for each case, but there have been instances where board of assessment would have been established. And for example, in the same holiday lands case that has been relied upon, you would see that there were at least 2 instances, and a third instance should have been engaged in dealing with that before the board of assessment.
And Ms. Matut, do you know if any money has been paid in this case? Any
Yes.
money?
Yes, we have paid.
What has been paid?
We have paid the award that would have been made by Justice James, as well as the landfill.
The 1 million plus?
Yes,
Oh, well,
Paid into court or paid out?
it
I
has
thought
been
the
paid
order
out.
was to be paid, it's been paid out.
It
'Cause
was
I saw
paid
the
out.
order was to be paid into court, but it's actually been paid out then, okay.
Yes, it has been paid out.
I am heartened.
Yes.
And counsel, before we leave, the matter of experts and the question in the rules, I recorded as a practitioner and a high court judge, of the duty of an expert being to the court. That seems to have been flagrantly violated seriatim in this case. Mr. Castillo's valuation was homage to his boss, the Commissioner of Lands.
Yes.
And Mr. Gardner's valuation was doing a job for my client who asked for this valuation.
Less egregious than Castillo.
Less egregious. That's why. No, that's what my language reflects the degree. But yeah, so counsel, could we not have this sort of thing in the future? And Mr. Smith, I'm very glad that your counsel would have encouraged counsel who appeared at first instance to the view that that $12 million claim for loss of income, etc., from a hypothetical development 10 years down the line could ever have been awarded by a court as damages. So I'm glad that you provided that guidance, and I commend you, and I hope that junior counsel will share the benefit of that guidance with his peers.
Obliged, Justice Barrow.
Okay, well, we take, sorry, Ms. Matute, is there anything further that you wish to say?
Your Honor, I just wanted to address some of the factual questions that the court had raised. One was in respect of the purchase price of the property. If the court could note, I believe it's at page 106 of the record, there is a transfer of land instrument, and therein it states that the consideration is $12,988.40.
Yes, that's what Mr.
Thank you for
Anderson.
this. I said, because I was wondering about seeing it somewhere. It was 12,000.
$988.
Could we have the benefit of your knowledge of these things as to what will explain that purchase price, when obviously this land could not, as a matter of commercial value, be worth 12,000 odd? Could you share with us?
As Mr. Smith, my learned senior, has indicated, in fact, when you're purchasing property from the government, it's at a significantly lower price than what it would fetch on the market.
And it would be in many instances that the land was being held on a lease before, one,
Yes.
or two, and therefore what is being paid at the time of transfer is a nominal figure rather than an actual figure. And as well, I think there may have been some history as to what made this land sold to this owner. But anyway,
Yes.
thanks.
And in respect of the query by Justice Sanders presiding, you had queried whether in fact there was some indication about a sale of the subject property, and I have reviewed the evidence of Mr. Gardner, and I do not see anything in there that suggests that Ms. Gabourel would have been in a position at that time to sell the property. In fact, what would have transpired is that I believe that there would have been an injunction at the point of acquisition that would have prevented any further steps being taken in respect of that property. And that issue was properly before the court. And that was a part of the delay in making any, I believe, claims or at least requests for the establishment of the land assessment board in these proceedings.
I see. Okay.
Can you speak to the issue with which we were dealing with a few minutes ago, the assessment board? You did indicate that there was the constitution of at least one board, but I think we're all agreed that that is the correct procedure, really, for dealing with these kinds of matters of evaluation. So I assume that you may need to get instructions from elsewhere, but I'm just trying to figure out whether we can look forward to more establishment of these boards going forward in the future, because that seems to be the way to deal with these things, as was raised by Mr. Smith and confirmed by the president. Can you sort of give us any promises in that direction?
Your Honor, I don't think that I'm in a position to make any promises on behalf of the ministry, but of course, I will make the necessary representations and indicate that this is something that the court wishes for us to seriously consider when we're doing these acquisitions. Because I mean, as it is, we are continuing to acquire
so
properties.
Disarmingly kind of you, Ms. Blatut. And sorry, I think I broke up.
Yeah, I think our brother is frozen there.
Sorry,
Yeah,
Ms. Blatut.
Yes, Your Honor.
You're back on.
Sorry. Yes. Ms. Blatut, I was saying that is disarmingly well put by you. We know that you cannot do that, but as you say, you're urging the ministry to act appropriately may help. And I think I would want to raise as well that in a claim under the Constitution, I'm not sure that the damages are limited to compensation for the compulsory acquisition of the land simpliciter, because it may be that additional damage being suffered is something that the court can have regard to, including that interest at more than 6% perhaps ought to be awarded, etc. So I think the authorities should bear in mind that there are other remedies open to the court to see that justice is done. Thank you.
Thank you, Your Honor. And I have imparted that information, and we are currently dealing with a matter similar. And so we are aware of the potential relief that can be granted in that regard.
Okay. I draw your attention to page 131 of the record, because I knew I had seen something. It's paragraph 24 of Mr. Gardner's document. It says sales contract. It is understood from the proprietor that a contract for sale of this property after development is in jeopardy. But clearly nothing was developed on that particular issue. But I knew I had seen something about a sales contract.
I'm guided, Your
Okay.
Honor.
Yeah. Is there anything further, Ms. Blatut?
No, Your Honor, that would be.
Yeah. All right. So I want to apologize to you both for dragging you out a little earlier. I know that it was 8 o'clock when we started in Belize, but this afternoon, members of the bench have a very important engagement, and we didn't want to postpone the case. So the only alternative was to bring it forward. So thank you for accommodating that situation. Naturally, we are going to take time for our decision in this matter, and we will certainly let you know when we are ready with it. Madam Deputy Registrar, you may close the proceedings.
Thank you, President Saunders. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rajnapley. Thank you, Mr. Justice Barrow. Thank you, Mr. Justice Jamadan. Thank you, Counsel. And thank you also to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Thank you.
Good day and thank you.